Hey, Attorney Sharon here, your Georgia Wealth Wellness attorney. I wanted to come in here and talk to you about co-signed debt and how it impacts you and the co-debtor when you're thinking about bankruptcy. So when you co-sign a debt with someone, you both are jointly and severally liable for that debt, meaning if you file bankruptcy, that co-debtor is still liable for that debt because you jointly both owe the debt for the full amount. So if you wipe the debt out in your bankruptcy, that creditor can still go after your co-debtor unless they file bankruptcy as well. So bankruptcy is only going to wipe out the debt for the person that is filing bankruptcy. It also can impact you when you have co-signed debt is if you are co-signed on an asset. So if you own a piece of real estate with someone, now if you're on a mortgage, that's just different. If you co-sign the mortgage, you both are just jointly liable on the mortgage. But if you are co-signed on an asset, real estate, a boat, something like that, you both jointly own that asset. So that asset is deemed part of your bankruptcy estate. So you have to keep that in mind when you're filing bankruptcy. If you jointly own an asset, if your name is tied to it in any way, that is part of your asset and it is part of your bankruptcy. So don't file bankruptcy and not fully understand or letting your attorney know your name is tied to something. I had a client not too long ago file bankruptcy. She didn't know her mother had added her onto her property. She had no clue she was on her mom's deed. Well, that is part of her house. You know, her mom put her in the deed. That means she jointly owns that property with her mom. So you have to be careful when you're filing bankruptcy and understand jointly debt will wipe it out for you, but also joint assets are considered part of your bankruptcy estate. So that is extremely important. And the last thing you want to do is file bankruptcy when your name is tied to an asset and you run the risk of losing that asset, okay? So just make sure you do your research, you fully understand what your name is tied to. That goes for bank accounts. If someone has you tied to their bank account, that is legally part of your bank account. So just understand what your name is tied to and make sure you fully disclose that so you and your attorney can decide if bankruptcy is the best option or make sure you're able to protect those assets that your name were tied to. Good luck with everything, and I hope this information helps, and I'll see you in the next video.